I will be describing and commenting on the legal system of Pakistan in more than one videos. The very striking system of the legal system of Pakistan is that it is, you might say, 99% inherited from the colonial British system. And despite more than 70 years of independence, it has not undergone a very substantive change except in a negative direction or in a more sloppy direction. If you read the various district gazettes of late 1800s of the British Indian Empire, you will find out that they seem to be very proud of replacing the local legal systems with the so-called code. By the code, they usually mean the code of criminal procedures and the code of the civil procedures. It is not that the Indian-Pakistani legal system did not have any court system before the British came. In fact, there was quite a system before that, but it was obviously not of this type of system. Whether it was very well coded or not, that I don't know, the prior systems, but it is inconceivable that any system of justice can work without a court. The hallmarks of the Pakistani legal system from the bookish point of view are the Code of Civil Procedures, the Code of Criminal Procedures, and the Pakistan Penal Code, and the various rules and regulations and orders of the high courts. So we have the written law and we have the so-called case law, where there are judgments of the Supreme Court and decisions on many aspects of the law which have not been otherwise separately legislated. Now, for a practical person who is on the street, if he has a dispute with somebody, or if he has been injured by somebody, or if a woman has been divorced and there are children to feed, and she is looking for the financial support from the former husband, or somebody wants to get a divorce, or somebody has been nominated in some theft, or somebody has been nominated in any of the hundreds of sections of crime of Pakistan Penal Code, then obviously he is in real trouble. The system of law is such that if you look at the possible maximum punishments which can be given for each of the hundreds of offenses which are listed, you get a feeling that the punishments in the code are very exaggerated for the type of crimes which are committed, which basically means that you will be forced to hire a lawyer. And that is one of the things which is obviously expensive and difficult for an average person. Second thing is, a very noticeable thing in the legal system is that the various laws, whether they are civil, whether they are criminal, whether they are acts of various types of organizations and so on, there seems to be no coordination between these in writing. In other words, where one would be applicable or all would be applicable or whatever, and usually the legislation just state that notwithstanding anything, any other law at the time being this. Now that creates a bit of trouble, because that creates a void, and that also creates a very big loophole for people to be subjective in their judgments. And then there is this issue of the law schools. Uh, some of the law schools appear to be very good, but this is not the case with every law school, and many of the law schools would be situated on the third floor, second floor of some building or something, and I don't know how many of them have got very dedicated buildings with playgrounds and a proper students community uh, attending regularly or not. I have seen many munshis becoming lawyers without leaving their jobs in the courts. Uh, Munshi in Pakistan is something like a you might say slightly incomplete type of solicitor, and most of them don't really have any special qualifications or something like that. Um, this is the type of scenario. And in fact, 30 to 40 years back, when I had my first visit to a court as a part of there was some type of curriculum, and we had to visit that as a student. And I was very surprised that in the ordinary courts, there was this crowding around the judge, and no decorum was being maintained. Although decorum is well maintained in the Pakistani courts, in the High Court and the Supreme Court. Generally, you might say the type of courts would you like to show to a foreigner are usually the High Court and the Supreme Court. Among the lower courts, usually it's a kind of tradition that the courts of the senior session judge, administrative session judge, district and session judge would be rather nicely regulated, and the courts of the other session judges would also be somewhat regulated, but the courts of the civil judges really are a place of crowd and confusion and so on, and they don't have sufficient space, and in the COVID season there's a lot of potential for spread of COVID, and there's not much botheration about that. Regarding the lawyer profession itself, generally speaking, there are several pathways, and there are several categories. In the Leaving the last 15-20 years, when private education and education has flourished considerably, generally speaking, the people who wanted to become lawyers were those who had somebody in law from the family, and that was a family profession, or it was somebody who does not want to join the army, or somebody who does not like teaching profession, or somebody who has not found good avenues in good universities, and they would just opt for, okay, let's go for an LLB, which used to be a 3-year degree probably, which basically meant that the lot of the liars was from the mainstream of the society, usually from the middle classes. However, lately, as the education and good universities have offered law degrees, sometimes at quite a cost and tuition fee, the average social content background of the liars is now gradually shifting. One remarkable thing about the liars community that they are generally, on a personal level, if you are not a client, they are generally very, very friendly people. I have not seen a community in Pakistan having better communication skills than lawyers. And lawyers, because of their good communication skills and street understanding, make a large part of the parliament, not in just Pakistan, but also in pre-independence India and in many other countries of the world. Uh, they are what you might call the closest to the Awami nature of our society. Have they got an elitist character? Usually, except for the leading lawyers, there is no elitist culture in our country. The way of paying for the legal system has got a lot of defects, and obviously the lawyers want the entire fee to be paid right in the beginning, and generally from the client point of view this is a great mistake. Because later on there is a tendency of not attending the court sessions and sending juniors and so on, and delaying the thing, and that type of behavior. It is generally advisable that when you are dealing with a lawyer, one third of the fee should be upfront and it should be paid forthwith. And next, one third should be at the time of commencement of the evidence phase, because lawyers have to exert quite a bit during the evidence phase and have to be present. And the last one near the when there is the argument stage. I think if somehow the client can force his fee schedule upon the lawyer in this fashion, he will be much better off. One of the very remarkable things about the petitions which are variously filed in the courts, the routine petitions in the lower courts, is that they have got great similarity to each other, irrespective of the detailed circumstances of the case, and most of these are churned out by the typists, who have these templates in their computers, and they just go on doing that. And it is very interesting that there is a particular type of English which is used in Pakistan in writing the petitions in English, and this type of English is somewhat, not only somewhat archaic, but sometimes it is not grammatically correct also. Obviously, a main strategy of the lawyers is to put only that much number of facts which are enough in the beginning for the case to be actually taken up by the judge and not dismissed forthwith. And the strategy generally is that you just go along and watch the moves of the other party, the other lawyer, and then you give more and more information and so on as it suits you. Now, this is not a very good thing because it basically means that the strength of the case doesn't lie in the fact of the law, but it lies in the wits and the command and the influence of a liar compared to the liar of the opposite party. It is much better that there should be a law whereby all the affidavits which you are going to present, whether in criminal court suit or in civil suits, and most of the material you have to present should be presented, or at least enlisted very clearly in the first submission, along with the legal precedents and along with the at least about 70-80% of the evidence on which you are relying and the arguments. Um, Now, this is not the case, and that is one of the reasons that many judges, they don't really read the case in advance. They have just seen it cursorily before they start the hearing, and they also rely on what you speak or your lawyer speaks in the courts, and the opposite party speaks, and not so much on the what is written in the initial plea, except when he has to write a final decision of the case. This has got some negative consequences because obviously a judge has to make up its mind on reading the case itself, but somehow it is not regarded as good in the legal profession to make up its mind very early on in the case. Uh, Another issue is that sometimes it is felt that since most of the cases are going to end up not in the Supreme Court at the end, but at best they are going to go to the High Court and may not go to the Supreme Court. Because Supreme Court and High Court, I mean, they take a lot of time and a lot of money in some categories of cases. This means that the lawyers who should be representing you in the High Court should have considerable experience, but doesn't seem to be the case, and the lawyers which don't have really considerable experience are enrolled in the High Courts. A very remarkable feature of the lawyers community in Pakistan is that there's a very active electoral uh, politics within the lawyers, and all the major political parties have their lawyers groups as well. And not only that, uh, if you visit any of the courts in Pakistan, you will not miss that there is always some election going on, and usually the elections are of either the Bar Council or the Regional Provincial Council or that of the Regional High Court Bar Association. They are very well contested, they are very seriously contested, and there are lawyers who spend almost 70-80% of the time trying to pre-position themselves for the next elections for some president, secretary, joint secretary, general secretary, and things like that. Uh, One of the things which is noticeable is if you read the CV of the various judges and the justices and so on, particularly in the higher courts, uh, what you observe is that a considerable number of them have either a political background or, affiliated with some political party, and lots of them have been office holders of such bar associations and so on. Now, this is a bit striking that the system of appointment of justices has got a strong political tilt. Obviously, there are requirements which every judge, every person has to fulfill before he is considered for the post of a justice in a high court. But what is surprising is that the number of the justices who become justices directly from the advocates and not through the career judges is proportionately very high. Um, and it is getting better now, but it is a bit strange that the career judges don't have a bigger quota because they started as either magistrates, civil judges, and then they rose up to the senior civil judge, and then additional session judge, and session judge, and something like that. And generally speaking, a person who has been inducted in the judiciary as a civil judge, a junior position, is more likely to retire as a session judge or an additional session judge rather than ending up in some higher courts like high courts or supreme courts. Possession of postgraduate or specialized degrees in law, considering that the laws are quite numerous in countries. I mean, you can have maritime laws and all types of laws, and there's quite a big mass of legislation also. But compared to that, it appears that there is not much in terms of postgraduate degrees, specifically for various laws and categories of laws, and there is a need to expand that type of training and specialized type of lawyers. I'm not surprised that Pakistan has lost many international cases, mostly related to compensation in international courts. Not at all surprised because that requires much more dedication to the duty. There are lawyers who spend a lot of time in libraries, but their number and proportion is much less. And there are no system of graded payments in the legal community. There are no, the basic issue is that one would have expect, that the fees of the lawyers should be proportionate to the amount of experience they have and the amount of postgraduate qualifications they have and their age and so on. But that is not the case, and this is a great cause of confusion. And then there is this 10% payment which has to be made additionally, the so-called the court clerks, munshis, expenses, and so on. Every paper which is of significance has to have a stamp put on it of the state, and so on. One of the biggest problems which the client faces is that there are too many cases in the courts. The result of that is that there are lots of adjournments, and there doesn't seem to be a coordination between the lower courts and higher courts. A person would have a date in a lower court at the same time the lawyer has a date in the high court or even Supreme Court. There should be a system of appointment. Interestingly, the legal system of this country is so strange that all the, let's say, 70 or 80 or whatever, depending on 200 applicants on a single day in the lower courts, are given appointment in the court at the same time. That is usually 8 a.m. in the morning. There is no timing system, although it is very easy to divide the court hours into 3 slots and indicate the slots to which you are allotted in the summons which you receive. Now, that is obviously not a good practice, particularly in the COVID season when you are in that pandemic, when you don't want people to collect too much in the courts. Now, the next question is that how does the lower court really function? One of the problems in the lower courts is their record keeping. It is, I won't say that it is very common, but it does happen from time to time that crucial documents would disappear from the court records at the moment, and sometimes with the connivance of the readers, of the judges, or some other person in the record keeper in the courts, What happens sometimes is that when a judge wants to write finally a judgment and he's looking at the file, there might be uh, some documents missing so that he cannot have look at it, and with the connivance of somebody there, which is basically indicative of the lack of any central digitizing or any other format of record keeping by which these things happen. Uh, Strikingly, in Pakistan, a petitioner can appear in person as well, and but generally speaking, there is a tendency to dismiss the application of petitioners in person uh, at one stage or at a later stage, um, and sometimes with very strong cases, and this is a not a very nice practice. Certain forms of laws are very often used in the courts of Pakistan. For example, in property cases, the suit for possession is very common, even though many of these cases are clear-cut cases of law of illegal dispossession, which is a criminal law with punishment. Uh, Generally speaking, in the taking of the evidence in cases, there is a lot of scope of improvement. I personally have seen that in the courts of Pakistan, where when they are translating to the court language, say in English of a vernacular, I have seen the judges translating it in such a way that it really changes the meaning of what the person has said in Urdu or Punjabi or whatever language he is speaking. This is a very dangerous thing, because a much better practice is that there should be a recording of what the witness said, and that record should be part of the case to ascertain whether the words were actually said or not. This is in fact quite common, and it is always advisable that if you know the language of the court in which they are going to record, try to speak it in that language. Although there is a provision that in case the judge does mistranslate something, the liar or the person can object to it, but that will be also recorded separately along with a memorandum. Obviously, that will enhance the problem. Lately, there have been many female liars, but the thing is that mostly they are sent to the judges for unnecessary adjournments. Adjournment is quite a problem in this country. And also sometimes the judges, without any intimation, they will just absent themselves, and any of the clients, they will not be intimated. Many of the lawyers would have come from other cities, and there is no, and they'll just come in the morning and they'll find out that the judge is absent. And even in the higher courts, what would happen is that the cases for which the summons have been issued would be cancelled at the last moment for some reason or another reason, which is quite a source of inconvenience for the liars which have come from other cities. One remarkable thing about the liars community, which I have observed, is that they tend to be quite a tough community in terms of the hardships they can bear in scorching weather, and they tend to have a very positive approach. And many of them, I've seen that they will even come in court at very advanced age, where they are supported by one or two people in order to argue their case or the case of their client. Then the personalization of a liar with the judge is unduly important in Pakistan, and it is in fact unduly important in many other countries of the world. But it is a fact that for judges, for liars who are overly successful in terms of client, or particularly those who have got a strong political clout, are sometimes given considerable leverage by the judges, and the judges they are a little bit afraid of them. And I have even seen some of the very well connected liars indirectly even express their anger or scolding of the judges, which is a very bad thing we see. Regarding the higher courts, that is the courts, the high courts and the Supreme Court. In the High Court, generally the systems are well, things are mostly computerized. The halls and various courts, generally they are well laid out, and there appears to be some form of discipline. The only problem in the higher courts is that there is a tendency not to encourage the litigant or his representative to present their case with any degree of energy and to keep a very low tone, and not to give too much time to each case and decide it very quickly. Now that sometimes results in the skipping of important information. Another very, very striking thing about the higher courts in Pakistan is that when somebody is imprisoned, or somebody's case is ongoing when he is absent for some reason, but it is especially concerned with those who are imprisoned and they have got their appeals in the High Court, there is no requirement or mandate for the actual prisoner to be there in the High Court. Now, this might seem very convenient in terms of avoiding the various unpleasant incidences, or to expose the judges directly in terms of safety. After all, these are often the highest courts where they will be punished, or they will be released, or whatever. And the result of that is that in many cases the judges are just seeing the files and the arguments and just seeing whether the lower courts acted in according to law or something, which is not the same as it is seen in the doctor's community. In the doctor's community, if a junior doctor has seen the patient, the senior doctor's job is not to just see the file whether the junior has followed the protocol. He examines the thing and he makes his own assessment. And obviously, in the High Courts of Pakistan, since the person is not usually present who is in the prison, in the court himself, so obviously he is at a disadvantage, and not only he is at a disadvantage, the courts are also at a disadvantage. You know that sometimes in cases of rape or something like that, there are sometimes allegations, and on the paper it might look very well, and if the judge would, let's say the justice would actually see the person on which a charge is made, he might find out that the person he gets even breathless on walking and is trembling, and how come he has done a very very ignoble type of, very forced type of rape or something like that. Same is the case in circumstances in which the uh, there is an age issue. Somebody has done a crime and you're saying it's a minor, and then there's some record that no, it's a major, or is a major and somebody says it's a minor. Obviously, these types of cases require that not only the file be seen, the person should also be seen. However, from the justice point of view, a Chief Justice of Pakistan was once telling me that we avoid to see the party which is on whose behalf the case is presented, even if it is there, because their appearances might influence us in the application of law. Well, there is some point in that. It's not that these types of arrangements are without a basis, but anyway, they do pose certain hazards. After having dealt with the various issues, there is a very fundamental issue, and this is the issue of the conflict between the Anglo-Saxon law, the Islamic law, the traditional values which we learn, and the general street impression, and other aspects which give us our cultural values. Now, for example, in Islamic law, generally speaking, uh, we do not find too many imprisonments as a form of punishment in the Holy Quran. Whereas imprisonment is the major form of punishment in the Anglo-Saxon law. Now that puts it in a somewhat different context, because punishment is important when you are characterizing a law. Supposing there is one offense for which there is just there is a corporal punishment in, let's say, in Islam, and there is just the jail sentence in that. You see, the problem with the jail sentence is that a person, and the law also accepts it, a person is responsible for the upkeep of his parents, of his children, of his wife, which has got the same force as that of a law. And when you send somebody to a jail for a long period of time, you are favoring the petition of one person, and you are violating the legal understanding of another person. Obviously, a child has a legal understanding with his parents that they will be taking care of them. This has got both legal basis and emotional basis. Then there is another problem, whether the law is blind. Theoretically, yes, the law is blind. But if you see the life of the Holy Prophet of Islam, which is the source of law of Islam, it appears that in many cases, when the Prophet of Islam was deciding the cases, he had an eye on the consequences of his judgments, the social consequences of his judgment. Now, this is very important because if the application of a law is going to have very detrimental type of consequences for not only the society at large, but maybe for the family he is trying to favor or is disfavoring. So the concept of a blind law is really not a good concept. Second thing is that the Anglo-Saxon law, the Greco-Roman law, or such type of laws are primarily monarchical in nature, and their fundamental value is to enforce the will of the supreme, apart from giving some concessions for the people for resolving their disputes. but they are basically kingly laws. On the other hand, the Islamic laws are basically have different perspectives in the thing. This brings us to the end of this first part of this presentation, and we'll continue in the next part that what are the various possibilities of improvement in the legal system, and what is it actually delivering at this time. Thank you very much for listening.